nawambibwa njala kakusa bukakasi twagabye omukulu yatigidde state Ssebufu nawambibwa nga 14 January bannamagye aba SFC okulongereza ku musango ku kyagenda mu maaso oludda olwabwe tusaba kooti omusango eba olunaku olulala sobola okutegeeza kooti okunoonyereza oluusi era naamusibiddwe kwa rimandi For the request, Jonathan Elotu. Elotu. E-L-O-T-U. Firstly, the accused person has been in detention for over 3 weeks. A habeas corpus application was filed at the High Court with the ground at Kampala. A hearing was held in that application. And the state made an affidavit to the effect that they do not have the accused person in that position. The ruling in that particular application is supposed to be delivered today at 9 o'clock. The ruling in that application, the habeas corpus application, is supposed to be delivered today at 9 o'clock. However, in order to fail that application, the accused person has been produced before you. And the state is saying they're still conducting investigations on the matter. There is a right to personal liberty, but an accused person must be produced before court within 48 hours. And such an accused person has a right to a fair hearing before court. It is upon that background that I believe it would be the interest of justice that an accused person, like the applicant, should be allowed to make a bail application. Worship, we have sureties. Your Worship, we have sureties which we are willing to bring to court's attention. My land friend will proceed with those sureties.
Your Honor, before court may decide to grant me or tries to make an application, I want to go to court, attention of court, to the fact that the allegations made are real.
This could be made in reply because the state does not have an opportunity to make.
I'm just doing an attention.
Maybe to reply to that after court makes that court
makes the ruling whether the application should be allowed for you to make bail.
What do you mean he has no, what? What do you mean they don't
Your
have?
Worship, I do not think he has the right to respond to me right now because I am now proceeding to the application. That is what I say, that my land friend is going to go and now start dealing with the sureties. So I do not see how states should now jump into
Your Honor, I
this.
thought he applied, he sought leave, but the court is yet to grant, to decide whether to grant or not to grant the leave.
That is it.
Yes, that's the position.
Your Worship, what had happened, I had informed the court, I had given court a background, and I told court that let me proceed to the sureties. And court had said, proceed to the sureties.
Okay, let's go slow. We shouldn't raise our tempers. Let's go slow. In your submission, you submitted. In reply, you even captioned state submission. When state said the inquiries were still ongoing, the investigations. So you're practically making the reply to states.
It should be the way I had not concluded because I had even said that we are now, my land firm is going to proceed with the sureties. So I had not yet concluded because my land firm is going to jump in, but state then
If you
jumps in
proceed
to
to the
say,
sureties,
yes.
and we're going delving into the arena of bail application,
Yes, Your Honor.
have I granted you?
Uh,
I haven't. He made a prayer seeking an adjournment that his person be remanded because the investigations are still ongoing. In your reply, you submitted that they cannot claim investigations are still ongoing because the accused person, or your applicant, you even refer to him as the applicant, has been in detention for over 2 weeks. You even made a bail application, a habeas corpus application to be produced at High Court. And the ruling was supposed to be delivered today, but they frustrated it by producing him in court today. And then you sought leave of court, you sat down, and you handed the microphone. They said that my colleague presents well. Sure it is. That is delving into the arena of bail application. So I think he has a right to even rejoin. Actually, this is a rejoinder. He made an application, he be remanded, investigations are still ongoing, he made a reply, he cannot claim the investigations, so he has a right to rejoin.
Must be graduate.
And that is when, from that basis, I will write my ruling whether to grant you leave to proceed with a bail application for him to present your sureties or not.
Must be
That is it.
Well, guided, Your Honor. Your Honor, defense counsel has raised very serious issues, allegations. He has not furnished this court with any iota of evidence that indeed the accused person has been in custody of the state for the last 2 weeks. And so I find that being misinformation. Unless others could have been proved by them. And I also don't think it's the intention of the state to frustrate an application, an alleged application before the High Court. I will reiterate that the inquiries are still ongoing, and we are praying that this matter be adjourned.
my client was one of the medical elements.
Why not make an application within an application?
Your Worship, maybe this could assist court, maybe just to comment on a certain section of what has been stated by
Who
us.
is commenting?
Yes, his
But
person.
now we apply, should we have given the accused person to represent himself or dispense with you?
Your Worship, of course not, but because he's the one who has instructed us, he has that right whether to dispense with us or even to make a comment.
But
to the
you've
court.
already submitted.
But he just wanted to say something small to court, just something small to court, clarify on something small.
So you want me to break the procedure? Okay, It is okay. That's unfair.
Ekitiibwa omulamuzi njagala kwebaza okumpa omukisa guno. Nawambibwa njala kakasa bukakasi twagabye omukulu yakiikidde state civil. Nawambibwa nga 14 January bannamagye aba SFC 14 January saawa nga 8 wakati w'ebyokulonda Entinda. Baali bannamagye nga bambadde ebyambalo by'amagye nga basukka 8 ne bankasuka mu mmotoka drone era n'empale yayibika wano singa gikola ku kibo omulamuzi ne mbikibwa ku maaso okutuusa bwe bantuusa gye nategeera oluvannyuma nti ye safe house. Era banzigireyo ku makya ga leero era nga bambisse ne banteeka ku Jinja Road Police Station. N'olwekyo ebyali byogeddwa kikidde state bya bulimba ebitali found in any way. Baba bakiikirya state, they should always learn to say the truth and nothing else but the truth. The rest of the court can take his decision.